Good afternoon, everyone, and a very warm welcome to you all. My name is Anne-Marie Lumsden. I'm the CEO of Legal Services in South Australia and the newly appointed Chair of National Legal Aid. And it's my very great pleasure to host today's webinar. We're here to reflect on the International Legal Aid Group, also known as ILAG, meeting held in Cologne, Germany in June this year, and to hear about some innovative strategies being implemented by Legal Aid New South Wales. Before we begin, I want to acknowledge the traditional custodians of all of the lands on which we are meeting today. I'm speaking from the traditional lands of the Kaurna people of the Adelaide Plains, and I pay my respects to their elders past, present and emerging. I acknowledge their enduring cultural heritage, knowledge and beliefs, and thank them for their care and custodianship of these lands and waters. I extend my respect to any First Nations person joining this webinar today. National Legal Aid recognises that these lands were never ceded and remain Aboriginal land. We greatly value our partnerships with First Nations organisations and leaders, and we thank them for their collaboration and the implementation work that we're doing together, especially in relation to our strategic plan. Today, we're here to share insights and learnings from the 2025 ILAG Conference. National Legal Aid was very proud to present at this year's event. For those unfamiliar with ILAG, it's a network of legal aid leaders from over 24 countries, including CEOs, civil servants and academics. The focus is on evidence-based policy making in legal services. ILAG explores developments in policy, research and the use of technology to improve access to justice. While traditionally focused on well-established legal aid systems, ILAG is now expanding its scope to include emerging jurisdictions as well. We have a very rich and thought-provoking webinar session today. First, we'll hear from Dr. John Borsig, who is the CEO of Legal Aid ACT, who presented at the international meeting and will provide a recap. Then we'll hear from several colleagues about new developments at Legal Aid New South Wales. Daniel Kennard and Dara Reid will present on child-centred services for children and young people in alternative care. Kiara Daly and Kerry Pearson will discuss a response to legal aid provider market failure in regional New South Wales. And then we'll open the floor to you in a question and answer session where the presenters will take questions from you. So it's a full agenda and I'm looking forward to the discussion ahead. So I'll now hand over to Dr. John Borsig to kick things off with his recap of the 2025 ILAG International Conference. Thank you, John.
Thank you, Anne-Marie, and hello, everyone, and thank you for coming into this presentation. I was there as the then Chair of National Legal Aid and also to present a paper which I did in relation to the private practitioners survey. The other aspect of what we do, almost all people do, is prepare a country report, and there are about 21 of those that were prepared. I'd encourage you to read them because they make fascinating reading because they present the state of legal aid in all those jurisdictions. And I suppose at heart, that's what happens at ILAG. It's an international conference. It draws on a whole range of people from a myriad of continents, east and west, south and north, and provides an amazing array of perspectives. The people who attend are a combination of academics and legal aid providers, as well as people undertaking innovative projects. And as Anne-Marie mentioned, there's been a drive over the last 10 years to include third world nations, and you'll see that that's been taken up in particular in the program that was this ILAG at Cologne. When you look at the overview of what was presented, you'll see that there are a range of immediate differences or practical differences you can see, innovations, But then you can also see some incredible similarities, things like funding, work conditions, and so forth. So when you go and look on the site at the papers, I think you'll see an array of views that will be exciting and interesting to explore, as well as really some very sad and familiar problems that we all face. For me, I suppose, apart from the Australian contingent's presentations, which were very impressive, what marked me most was the Jordanian women who have set up a domestic violence service in Jordan. I can't underline how difficult that was for them. Meeting with them, talking to them, listening to their presentation was just inspiring. To achieve what they have achieved without the kinds of support that we have was just amazing. And I'd encourage you to have a look in particular at their presentation. What we'll also do, apart from the presentations that you'll hear more of soon, we also highlight in our country report some of the amazing initiatives around Australia. And I mean, there are multiple, but we highlighted, for example, the Disability and Advocacy Referral Division of Young People Project in Western Australia, which is a therapeutic approach. We highlighted the Youth Justice Fast Track Sentencing Pilot Program, which is an initiative in Queensland, which includes Legal Aid Queensland, but also embraces the other services. We also discussed the early advice work that's being done between New South Wales Legal Aid and the Aboriginal Legal Service and the New South Wales Community Services in relation to care and protection. And you'll hear more detail of the work that they're doing there. We highlighted some of the work we're doing here in HJPs, Health Justice Partnerships in Legal Aid ACT. On a national level, not a lot of people know what NLA does. And if I can just underline how important NLA is at a macro level in our relationship with government, in particular in terms of developing the advocacy around how we present our case for funding, but also our views around a range of topics that affect Australians and our clients nationally. NLA coordinates that work and is doing it very well. The other thing that they coordinate is the evidence base. And if I can just remind you, and you'll probably remember these, the Justice on the Brink report was coordinated. Evidential basis about what we need to achieve in our system. They're coordinating the work with the ABS in terms of the data we have to do. And of course, have to provide. And of course, the private practitioner survey, which I spoke about, really the work that's done, what we need to do to support the private practitioners who do a lot of the work for us, particularly in regional and remote Australia. So in overview, it was like many of the conferences have been. It was interesting, it was varied and diverse, but it underlined the importance of this work of legal aid right around the world. So with that, I hand back. Thank you.
Sorry, I had some problems with the mute button. But thank you very much, John, for your recap of the conference and for your presentation at the conference. I'd now like to welcome Dara Reid and Daniel Kennard from Legal Aid New South Wales. Daniel is the solicitor in charge of the Children's Out-of-Home Care Advocacy Service, and Dara is a lawyer with the Social Impact and Systems Change team. They're going to be presenting on child-centred services for children and young people in alternative care. Thanks, Dara and Daniel.
Thank you, Anne-Marie. And Dara and I would also like to acknowledge the traditional owners of the lands in which we're joining this webinar, which Dara and I are in Haymarket, and that's the traditional land of the Gadigal people. We acknowledge the stolen generations who never came home and the vast overrepresentation of Aboriginal children and young people in out-of-home care across Australia. By many to try and change this tragically upward trajectory. We acknowledge the Aboriginal and Torres Strait Islanders who are joining us in this webinar, including our colleagues. We are very grateful to ILAG and delighted to have this opportunity to share our presentation about Your Voice Children's Out-of-Home Care Advocacy Service with you today. Your Voice is an interdisciplinary specialist socio-legal service for children and young people in out-of-home care. At its core, Your Voice is designed to enable and empower children and young people who live in out-of-home care to have their voices heard and to meaningfully participate in decisions that affect them and impact their lives. We received funding to establish Your Voice just over a year ago, and once we'd received that funding, we consulted last year we consulted very widely, including with children and young people with lived experience in out-of-home care, to design and then stand up the service. Dara and I are super passionate about the work that we're doing and the model of service delivery we're developing. We wanted to share that passion with the ILAG audience, which, as John's noted, are really different to the audience that we're used to presenting to. So there are a lot of administrative civil servants and research people there. And we wanted to infect them with our enthusiasm for the service. And for that reason, this presentation, the one that we're delivering right now, is pitched at a kind of an abstract level, and that, on the other hand, at quite an emotive level. So we acknowledge that. It describes the experiences of our clients quite intimately. We have prepared a very detailed paper which outlines the theory, history, and practical implementation of Your Voice, which, if you're interested, we'd encourage you to read. It will give you many more details. Ultimately, it's our hope that this presentation prompts some reflection on how the legal assistance sector can better respond to the unmet legal and wellbeing needs of children and young people in out-of-home care, and in doing so, uphold their human rights in practice and in their everyday lived experience in out-of-home care. It's really important for us to acknowledge right up front that we're just here as representatives of the Your Voice team, and it's the excellent, adaptive, individual and collaborative practice of that team that's turned the theory and ideas associated with Your Voice into practice and reality. And I think Dara does too. We thank our team for that. We think that listening to the voice of children and young people is fundamentally, we think that when listening to the voice of children and young people, it's fundamentally is about their right to tell and control their story. And so for that reason, we begin this presentation with some storytelling about the genesis of the service. So if we can go to the next slide, please.
My first foray into legal advocacy in court was as a criminal lawyer. This is a picture of me in the Tiwi Islands at the top of Australia back in 2011 in the back of a police divvy van. I hadn't been arrested. The local police officer was picking us up from the tiny airport and taking us to Bush Court, something that many of you on this call are probably familiar with. I was working at NAJA as the managing lawyer of the youth justice team, and this was a moment of bizarre levity in amongst some unforgettably tragic insights into the youth justice system. My work as a criminal lawyer, and in particular as a children's criminal lawyer, took me to courts and detention centres across the top end of Australia, Central Australia, and to Sydney as well. And there are clients that I'll never forget, clients like Evan, who was only 13 but had so many files they'd stack up like so high in and alongside my in tray. Among the various files for break and entering company in various forms at various times of the day was file after file for breaching bail, almost always by leaving his out-of-home care placement to return home to his mum. I remember how withdrawn and non-communicative he was, and if I'm honest, I'm plagued by a sense that I failed him, when at one point in his repeated contact with the criminal justice system, he received a really long sentence of detention, which we appealed but lost. With each additional layer of professional experience, I think about what I could have or should have done differently, and about how the systems he was part of failed him and his family. His mother, who I also represented in court on other occasions, is a victim survivor of DV, sexual assault, and a member of the Stolen Generations. The thread that runs through my experience as a former children's criminal lawyer, seeing children and young people in out-of-home care in the cells and in detention, is a sense that this wasn't right, that the system, and myself implicated in that, were not meeting the true needs, not doing justice for these children. I felt strongly that detention wasn't and still isn't the answer, as I'm sure many of you do, and that the answer was far deeper and more complicated. It seemed to me that sadly, if we truly wanted to meet the needs of these young people in out-of-home care, we needed to commit time, attention, and resources to supporting them many, many years before they turned up in the cells.
It's trite to assert that our lived experience impacts our thoughts, feelings, and actions. What happens to us inspires, guides, and limits who we are, what we do, and how we see the world. Previous slide, Dara was in the back of a divvy van. In this slide, I'm in a town camp working as a child protection worker, caseworker. And I've transitioned from being a child protection caseworker to a psychologist, working in Dondale, and then eventually to becoming a children's lawyer. As lawyers, we see, hear, and absorb the parts of the lives of our clients choose, either voluntarily or involuntarily, to share with us. Sometimes all we get is our client as described in a fact sheet, and other times we're overwhelmed by the voluminous material that's produced to the court to assist us to argue our case. Whilst as lawyers, we always provide clients with the chance to be heard in relation to the critical issues at hand, we're also obligated to selectively listen. Client stories shape case theory, and case theory will determine what we need to hear from our clients. Slide 4, please. Let me just introduce Alice to you. She was taken into care as a result of neglect and sexual abuse. She was placed with family, but it broke down when her kinship carer died. She has behavioural issues, a mental health diagnosis, and criminal convictions for malicious damage. She lives in a 3-bedroom home. She has 1 bedroom and the other 2 are for staff. She has staff with her 24 hours a day. She's really sad because her younger siblings are in her mother's care still, but she doesn't get to see them very often. She doesn't know how to talk to her mum, and when they get together, all they can really do to have joy is swap TikToks. As lawyers, we might see Alice as a child in care or a victim or a person with a mental illness or even a defender. We see Alice in terms of what we can offer to assist her. But when we ask Alice who she sees herself as, she says she doesn't know. She's a daughter, but she doesn't know her mum. She's a child, but she doesn't know what her childhood really looks like. She's a mental health patient, but doesn't really have a reason to get better. She's a friend, but only to a paid carer. She's in care, but she doesn't feel that anyone actually cares about her. She tells us that she thinks she's invisible, but not like a superhero, just like somebody who's never, ever seen. Sometimes, to make an enduring difference, we need to take off our lawyer hat and the veneer of protection it offers us as people and hand over at least some control to our clients. We need to listen to them not as defendants or child parties or person in need of care and protection, but as a person enmeshed in a complex system of interconnected parts, none of which have sustainably met his or her needs, and all of which could be collectively causing her harm.
Many of you, but maybe not all of you, will be familiar with the idea of systems thinking. It's a concept that's been applied in community development for a long time, more recently in government policy, and more recently still some legal scholars advocate that it's paradigm relevant to legal advocacy. Systems thinking is a holistic approach to understanding complex problems by viewing them as part of an interconnected network rather than isolated issues. In the context of legal and social systems, it recognises that outcomes, such as those experienced by children in out-of-home care, are shaped by the dynamic interplay between systems like the justice, education, health, and welfare systems. And these systems influence each other through feedback loops, where outcomes reinforce or exacerbate future conditions, either positively or negatively. A circuit breaker is a strategic intervention that can disrupt harmful feedback loops in a system, aiming to catalyse transformative change. Your voice aims to act as a circuit breaker, using the lever of legal advocacy coupled with allied professional expertise to change the short, medium, and long-term life outcomes for our clients.
Globally, there is an estimated 2.7 million children living in out-of-home care, and of those, about 45,000 children come from Australia. Tragically, across the globe, Indigenous children and young people from colonised countries are vastly overrepresented, and this trend is increasing. It's well established that children and young people in out-of-home care are one of the most vulnerable, disadvantaged, and traumatised groups in our community. There's a large body of academic research detailing the adverse impacts of institutionalisation on the wellbeing and developmental outcomes of children and young people in out-of-home care, the complexity of their needs, and the over-representation of them in the criminal justice system. Most studies and reports document poor life outcomes for care leavers. They're more likely to be unemployed, homeless, experience poverty and mental health issues, and have a high risk of mortality after leaving care. Slide 7, please. Viewing the poor outcomes of children and young people in out-of-home care experience through a systems thinking lens, we think it becomes apparent that there's a critical need for legal aid agencies, which are mandated to provide access to justice for the most vulnerable, to expand those services beyond the traditional legal frameworks, which focus primarily on court-based or connected interventions at particular points in time in the litigation process, so that this incredibly vulnerable cohort can access legal advice and assistance whilst they're in out-of-home care and after the court process has been completed.
So Your Voice is a small specialist service led by Daniel. It's an interdisciplinary team of lawyers, care and protection, as well as civil lawyers and allied professional staff of senior social workers and an Aboriginal field officer, as well as a project officer and admin staff. To give you an insight into the team and their work, we want to share with you a video that was produced in collaboration with Sam, an Aboriginal man who describes himself as a survivor of out-of-home care. Caitlin, it's just that previous slide, yeah. Hopefully the sound's working. Maybe I wonder if
I don't think that sounds good.
maybe what we might do while Caitlin's doing that is just carry on a little bit until she's able to get it back to the start. So to give you an insight into some of our client work.
We'll just briefly share the stories of two young people. Alex is 15. She identifies as female, but was placed in a male care home. After prolonged taunting and non-recognition of her gender identity, she was charged with assault, I guess in retaliation. With Your Voice support, she secured alternative housing and a non-punitive legal outcome in relation to her criminal matters. Her engagement with Your Voice remains slow and challenging. We work at her pace, and we're really keen to continue to work with her to meet her needs. Sophie is a 17-year-old Aboriginal young person and a survivor of sexual abuse. In the 2.5 years since she was removed from care, she'd cycled through 8 placements, including 1 placement in a hotel. When we met her, she'd found her own placement and she'd asked her friend to be her guardian. Your Voice, our service, supported her negotiate with DCJ in relation to whether that was a realistic and achievable outcome for her. But we also assisted her navigate the complex issues arising from her mental health, care with her siblings who remained with her mother, securing a cultural safe environment for her, and generally assisting her to understand the processes by which her life had taken such a wrong turn. When we asked her some questions about what her greatest wish was, she told us it was to be valued in the system as more than just a victim of her experiences.
2 examples of the outcomes that we're helping clients to achieve, and solicitors and the allied professionals in the team are helping clients to achieve, include supporting a young woman who's pregnant and was at risk of having a child removed at birth to be able to keep her child when they arrive and to have access to family and other supports. And supporting a young woman to open up and share with her caseworkers that she was in a DV relationship and wanted support to leave it. The caseworkers then immediately supported her to move away from her partner to a different area and access short-term accommodation. Just checking in with you, Caitlin, do you want me to share my screen and press play on the video? I might just try that. Is that working or no? No, not working. We might just keep going.
So if you can just flick through 2 slides. To slide.
Oh, Caitlin's probably trying
Sorry,
furiously
Caitlin.
in the background.
Next slide, please. And then the next one after that, I think. That one, thank you. This is an overview of the main legal issues that we were assisting clients with at the time we collected this data, which was about the end of May. You'll just observe from that slide that the main issue that young people had identified as a legal issue for them were issues relating to changing their placement, issues relating to having contact with family or kin, aftercare planning, access to basic needs, which included access to internet as well as shelter, food, and other issues, educational issues, and access to disability supports and guardianship. The next slide, please. So Your Voice also assists aims to work with young people in relation to wellbeing issues. And this is a slide that details the main wellbeing issues that have been identified by the wellbeing team. And unsurprisingly, there's a significant correlation between the two because our theory is that legal issues are driven by unmet wellbeing needs. Next slide, please. In our service, legal issues facing young people are seen in the context of their wellbeing, as well as arising as a result of unmet wellbeing needs. Understanding the child and the young person in the context of their wellbeing needs means that artificial silos around legal issues, for example, whether an issue is a civil law or a family law issue, a care and protection issue or a crime issue, and other socio-legal issues, such as the criminalisation of behaviour in response to placement issues, are removed, and the young person has the opportunity to resolve legal and socio-legal needs holistically. This collaborative model challenges traditional legal practice by embedding a holistic, client-centred approach from the moment the referral is accepted. It enables more creative, effective advocacy and has helped us to build strong, cooperative and productive relationships with service provider, which ultimately we hope we can demonstrate, and we have demonstrated, led to improved outcomes for the young people we've supported. This is a representation on the screen of that wellbeing model where the young person's centred in the middle of the model and the wellbeing needs arise from the centre of the model, and legal advocacy is on the outside. Next slide, please.
So despite what's contained in the UN CROC and UN Convention on the Rights of the Child and local policies and procedures, the reality is that children and young people in out-of-home care often feel voiceless, unheard and unseen. There's some quotes from a New South Wales-based report speaking with children and young people in out-of-home care. Our service, Your Voice, aims to restore that voice, empowering young people to speak, be heard and participate in shaping their own futures. As Alicia Savas, who might be on the call today, highlighted in her Churchill Fellowship report on child-centred services in child welfare law, if the systems, processes and individuals working with children do not enable children to participate safely in matters important to their lives, we fail to uphold their human rights, and children's access to justice is limited. And shout out to Alicia for a fabulous research report.
For a child or a young person to speak up and be heard, they need to feel and to be safe to engage. To be safe, a child or young person needs to have agency and they need to have power. The unique qualities of the lawyer-client relationship can provide such protection. Services provided by lawyers on instructions will attract legal professional privilege, and this creates an exclusive space where a child or young person has the power to control some aspect of their life. That power is not only to determine what services to be provided, but perhaps more importantly for children and young people in this space who has a history of the information they share being weaponised against them, often under the guise of their best interests. A child or young person who has access to a lawyer will be able to have control over what information is used and how that information is used.
So on that last slide, you saw some of the things that children and young people that the team have helped through the service have said to their lawyers or to the wellbeing team staff, unprompted. Things like, I feel like you're the only ones who care and that no one else has ever wanted to listen, which is obviously pretty powerful. While Daniel and I both share this professional connection to working with children and young people in out-of-home care, there's aspects of our personal lives that also intersect with the out-of-home care system. I was in out-of-home care briefly before being adopted. My parents actually picked me up from the building I'm in today, the legal aid building, and Daniel's brother became part of his family through adoption. In addition to our professional lens on the system, for me at least, when my professional world has come into contact with the lived reality of clients in out-of-home care, I've been really viscerally aware of the contrast between my experience and theirs and the incredible gap between the two. I can't tell you how many times I've sat opposite clients in conferences, in court, or in the cells, thinking, but for my adoption, my client could have been me.
So to close, and recalling that this was an international conference where we were trying to find some common ground, we reflect on the story of the Little Mermaid. Most of you probably know this famous fable, and it's been turned into a Disney cartoon and an animated film about a mermaid who, in her quest to live on land, sacrifices her voice and, we would say, her power to affect change. The song If Only, which was on the previous slide, speaks about her experiences of being voiceless. And we think that, strangely enough, that commercial song encapsulated a lot of what young people in out-of-home care may experience. When she's reunited with her voice, she experiences what young people in out-of-home care undoubtedly strive to experience: belonging, agency, connectedness, and selfhood.
So we invite you to consider whether there's a need for a service such as this in your part of Australia, your jurisdiction, and you're welcome to reach out to us if you think that we can assist you, or if you want to speak to us further after having a read of the paper. Just with the video, I'm not sure how we're going for time, but I did send Caitlin the link if she's able to just press play and share her screen, but we might need to come back to that. It's a tricky job being on tech for these large webinars. Maybe we can sort it out at the end.
It is available on the Legal Aid website, and if you search for Your Voice, the video is there. Thank you very much.
So thank you, Dara and Daniel, for your presentation. It was extremely moving and thought-provoking, but you also entertained us, so that was great. So we're now going to hear from two other legal aid colleagues, Kiara Daly and Kerry Pearson. Kiara is the Solicitor in Charge, Care and Protection in the Family Law Division, and Kerry is the Acting Practice Development Manager in the Family Law Division. They're going to be presenting on local solutions to a global problem, piloting a place-based response to legal aid provider market failure in regional New South Wales.
Okay. Thank you so much, Anne-Marie, and thank you, Dara and Daniel. It's a very hard act to follow, and the second time I've now heard it, and as close to tears as I was the first time. So I'm coming to you today from the land of the Awabakal and Worimi people, and I would also like to pay my respects to elders past and present, and to any First Nations people joining today. So Kira and I are really appreciative of the opportunity to join such a wonderful group of people and be able to speak to you today about something we've been working on, the Care and Protection Professional Development Initiative, or CAPD as we've been calling it. CAPD is a place-based pilot program that's been developed by Legal Aid New South Wales to address a growing crisis in legal aid service delivery in regional New South Wales. So if we can go to the next slide. So legal aid in New South Wales, as many of you would already be aware, is provided using a mixed model of service provision. So services are provided by in-house lawyers, community legal centres and private lawyers. We know that private lawyers are integral to the success of the mixed model, with a significant percentage of legal aid services being provided by private lawyers on Legal Aid New South Wales panels. So in New South Wales, panel membership is by law practice or firm. There is a single application for a law practice, and the applicant can nominate which individual panels they wish to be included on personally, but also nominate any lawyers within their firm. There are individual panels for various areas of law, each having specific requirements that any nominated lawyers must meet. These panels are also further divided by region. For some of these panels, work can also be delegated to associates of the law firm who do not otherwise meet the panel requirements, meaning that junior lawyers are able to get experience in these areas of law. For some time, Legal Aid New South Wales, like many other legal aid commissions, have struggled to maintain an adequate number of private lawyers willing to do legal aid work while still maintaining a high standard of quality of legal services. So we can go to the next slide. So we know from the National Legal Aid Census and from anecdotal feedback received for many years that there are many pressures that impact on this, but the main issue consistently raised is the financial viability of undertaking this work. In New South Wales, like in other Australian jurisdictions, legal aid fee scales are paid at a rate that is much lower than market rate, have seen little increase in decades, and have not been able to keep pace with increased costs of practice. This is a result of limits on government funding, despite the benefit of the provision of legal aid services being provided nationally being estimated at $600 million a year, and despite advocacy by Legal Aid New South Wales and other peak bodies to increase funding. The issue of attracting and retaining panel lawyers is particularly acute in regional New South Wales. Research suggests that generally, that in more remote communities, there are higher levels of socioeconomic disadvantage, higher proportions of Aboriginal communities, and lack of access to appropriate services. These are all factors that are associated with people having multiple complex and often interrelated legal and non-legal needs. In New South Wales, there are regional areas that are serviced almost exclusively by private lawyers. In many regional areas, the loss of a single lawyer from the Care and Protection Panel would have a considerable impact on the delivery of services to the most vulnerable members of our community. In some areas, the loss of a single lawyer could potentially bring about complete market failure. So if we can go to the next slide, and I will hand over to Kira.
Good. Thanks, Kerry. Okay, so I gave at the presentation an outline of the New South Wales Care and Protection System, given it was an international audience. So I just wanted them to get a sense of the lay of the land in New South Wales. So I outlined that obviously when the department removed a child from a parent, that can be the most significant intrusion into that family's life. And from the outset of this removal taking place, the department, there's a huge power imbalance because the department have all the knowledge, the experience. Then up against them, he was often highly distressed and in desperate need of some assistance and guidance to be able to navigate the children's court process. So a key reason that it is important to be represented in care proceedings is to protect our clients' interests. So whilst the government may have valid reasons for removing a child, for example, the client might not always get the outcome that they want, such as having their child returned home to them. It is fundamental that in order to have access to justice, that a party is represented and receives legal advice throughout the children's court proceedings. So whilst the Children's Court Practice Note in New South Wales states that the Children's Court aims to complete 90% of care cases within 9 months of commencement and to complete all cases within 12 months of commencement, in reality, what we see in New South Wales is most care cases go on for much longer than 9 months, and many take a number of years before they're completed. So there's many points throughout those care protection proceeding timeline where access to legal advice is critical, such as agreeing to particular orders, having input into matters such as the nature and amount of contact visits that a parent has with the child, and where a child is placed in the short term and the long term. I then outlined how matters in New South Wales are allocated when a child is removed. So in New South Wales, a children's court application must be filed within 3 working days of the child being removed, and children's court matters are then allocated on the mixed practice model. So some matters will stay in-house with legal aid and a legal aid solicitor will have carriage. However, for many reasons, as Kerry just outlined, legal aid obviously can't represent a party in every matter, including obvious matters, conflict of interest, capacity. So the majority of the legally aided work is conducted by panel solicitors. So the obvious issue with there being a shortage of care solicitors across the state is that essentially there's too many matters filed in the children's court and not enough solicitors to represent all parties at the bar table. And whilst we need more solicitors to do this work, given the extremely important nature of this work, we want to ensure that those doing the work are skilled and knowledgeable in the area of law. So we want to address the supply problem, but also ensure there is quality representation. So how we've done this quality control to date is in order to be on the Care and Protection Panel, to do this work, you're required to have 5 years of experience. The difficulty with this 5-year requirement is that there are very few private firms who do child protection work, and the data tells us that there is an increase in sole practitioner firms in New South Wales. So many solicitors are opening up their own firm, but with no junior solicitors. And then essentially there's no succession planning. So when a solicitor retires, there's no one there to resume the work that they were picking up for that local area. And the only other really ways to gain experience in care and protection work is working for the other government agency, DCJ, or for Aboriginal Legal Service or community centres, community legal centres who do child protection work. Just additionally, another quality control that we have at Legal Aid is in order to represent children, then solicitors are required to attend a child rep workshop and successfully complete that. So that's a day where people are assessed on their knowledge of child protection, and then they either pass, fail, or they go through further assessment. And just the next slide in regards to RPPS. So another way Legal Aid has addressed this supply issue to date has been to create a scheme called the Remote Preferred Provider Scheme, known as the RPPS. This scheme involves solicitors servicing regional areas where there are not enough care solicitors by appearing by video or telephone, except for matters like mediations or hearings. So for those New South Wales listeners, we already have this scheme working really well in Broken Hill, Moree, Far South Coast, Riverina. So whilst the RPPS is an effective short-term solution, and the feedback that we have received from the judiciary and the solicitors that are involved in this has been generally very positive, it doesn't develop the legal community in the local region or skill up solicitors in that local town to be able to represent parties in child protection matters. Also importantly, appearing via video obviously is not always the best method of delivering a service to a client. There are many benefits of obviously being in person with your client, particularly in a care and protection matter, where parents are often distressed and confused about what is going on. What we've also heard from across the state is that panel lawyers are more reluctant to travel to court these days. So the cost and time that is taken up with travelling to regional courts is becoming a significant issue for them. New South Wales is obviously a very large state, and many practitioners are required to drive or fly to court for many hours, sometimes just for 1 or 2 court matters. And whilst they are paid for this travel by Legal Aid, it still isn't feasible for panel solicitors to be doing all this travel, taking time away from their practice just for a handful of matters. So this is another reason whilst it is so important to build up local areas with local practitioners so that they can fill the gap in the market, as in the future it's becoming apparent to us that fewer and fewer panel solicitors are going to be willing to travel to attend regional areas to appear in care and protection matters. Kerry, I'll hand over back to you.
Okay, so now I'm going to talk a little bit about what we plan on doing about this. So as funding to increase fees has not yet been forthcoming, Legal Aid New South Wales has had to look for other ways to attract and retain suitably skilled and experienced private lawyers to undertake legal aid work. For a number of years, Legal Aid New South Wales has implemented various changes to our systems, processes, panel structure and quality assurance framework to address concerns raised by and about panel lawyers. To continue and consolidate this work, a manager of practitioner relations has recently been appointed, and I think Maura might actually be on the link today. And she's working to identify, develop and implement strategies and solutions organisation-wide to improve the attraction and retention of panel lawyers. We understood, however, that such a large-scale organisational-wide approach would take time, and the situation for the care and protection jurisdiction in many regions was at or is nearing market failure. And although, as Kira had discussed, there had already been short-term solutions implemented to address immediate needs in some regions, it was identified that a longer-term solution was needed and as soon as possible. We also realised that we needed to approach the issue from multiple angles, that this was not an issue that would have a one-size-fits-all easy fix. So we can go to the next slide. Our proposal is to pilot a tailored place-based initiative to attract new private lawyers to the care and protection panel and to enrich and support local care and protection panels. So we've decided to pilot the initiative in 3 regional locations that have Legal Aid New South Wales offices. The 3 pilot sites were selected based on a consideration of a number of criteria, including the need for panel lawyers and identified strengths of the region that could support the implementation of the initiative, some of which in terms of the program is set out on the slide here. So an analysis of available grants data looked at where we have a shortage of panel lawyers taking on care and protection work and where this was placing acute pressure on in-house legal aid lawyers. In addition to the analysis of grants data, we considered anecdotal feedback that we had received in relation to undertaking care and protection work within the, we had received in relation to trends in allocating care and protection matters and panel lawyers who were likely to reduce or cease undertaking care and protection work within the next 12 months. Once the locations were initially identified, we worked with the local legal aid officers to confirm the current state of the profession in the regions and to build region-specific plans to address the issue of attraction and retention of care and protection panel lawyers. What we found was consistent with our initial understanding of the landscape for care and protection panel lawyers in regional New South Wales. Although each of the regions had unique characteristics, many of the challenges raised were shared, including that local private lawyers who are already on legal aid panels are not feeling valued, particularly compared to their colleagues in metro areas, that the numbers of lawyers on the current care and protection panel is not reflective of what is happening on the ground. Many lawyers still on the panel are not active and or are only accepting certain matters, although we did see some variance here in what type of matters were being accepted in each region. And there were several complaints other than financial that local panel lawyers had in each region that contributed to their leaving the panel or reducing the amount of care and protection work they were willing to take on. If you can go to the next slide. CAPT is still in its early stages, but it is an intention for evaluation to be built into the design. So we'll be tracking the uptake and completion of the lawyers who go through the development program. Actually, sorry, if we can go back to the previous slide, I had it a little bit out of order there. And the structure of this program will be tailored to meet the needs and build on the strengths of each region and will, as set out here, consist of a suite of variable components, including modified eligibility requirements, an expression of interest process, completion of an intensive training program, a requirement to be on the duty roster and available for allocation, and mentoring by an experienced care and protection practitioner. And then at the conclusion of a predetermined period of time in the program, these practitioners would then be able to participate in our child representation training and on successful completion be appointed to the panel. So we'll be tracking, as I said, the uptake and completion of lawyers in this program, the number and nature of complaints made in relation to panel lawyers, as well as the attrition rate of panel lawyers in the pilot regions as compared to the previous years in other regions, and stakeholder feedback and client outcomes. Our long-term vision is a thriving local care and protection panel, reduced reliance on remotely provided services, and better outcomes for children and families. Thank you.
So thank you very much, Kiara and Carrie. It was really interesting to hear about this initiative, and we look forward to hearing about the outcome of the pilots that you've spoken about. I think that the video might be working, so I'll hand back over to Daniel and Dara.
Okay, I think Caitlin's going to try and give it a shot from her screen quickly. Otherwise, I can try to. So I think if I share screen, I mean, can you guys hear the sound? No. Okay, I think we might need to make it from Caitlin's on it. I think. Oh, there we go. Yeah. If the sound's not working, we can just share the link to the video for people to watch. It's just a 3 or 4 minute video. It just brings the amazing team to life.
Yeah. Okay. All right. It just will not work for us.
No. Tech.
No. All right. So it's now time to bring our presenters back for a Q&A session. If you have any questions of our presenters about the initiatives that they've spoken about today, please add them to the feature at the bottom of your screen. It's a box with a question mark inside it with Q&A underneath it. Okay, so we have one question. In relation to the regional pilot to develop local care and protection panels, aside from financial, what are the other complaints and reasons for leaving the panel?
So probably one of the biggest ones is what Kira had spoken about is around travel and expectations put on practitioners particularly by the court. So pain points have included things like having to file in person and having to file 3 days before a matter is listed, not being able to appear by ABL. And this is particularly difficult for regional practitioners who are appearing in several different courts across really large geographical areas. So they're probably the biggest ones that we heard. Another is lack of available training and resources, or the same training and resources that we have or that they see that we have in-house, and it being really metro-centric, so having to travel to Sydney to be able to undertake face-to-face training. So those are probably, I think, the two biggest complaints that we had, unless, Kira, there's anything that I've forgotten.
Okay, thank you, Kerry. We have another question for Dara and Daniel. I'm curious as to how cross-disciplinary initiatives like yours are funded.
Thanks, Catherine. At the moment, in New South Wales, we have a Law Society has a public purpose fund, and we applied for funding for 1 year, and then we got another year of funding just recently from the public purpose fund. So that's the short answer to your question. The slightly longer answer to your question is that we're doing a lot to engage and meet on both an operational and a more strategic governance level with our Department of Communities and Justice. And we have some encouragement, I would say encouraging signs from them in the context of a broader New South Wales reform of out-of-home care that's happening, that there might be scope in the future. Yet the short answer for now is through this public purpose fund, but we're sort of building it very much into our process and just setting up an evaluation so that we can try and support any future business cases to government for ongoing funding. Hope that answers your question.
Yep, thank you, Dara. We have another question for Kerry and Kiara. How long does the regional pilot program go for? Has it finished or is it currently on foot?
We're actually just getting started. So we are, in terms of the pilot, we're looking at a period of 2 years. And so that includes that key piece around the development program. So bringing on practitioners who wouldn't usually meet the criteria to sit on the care and protection panel. And throughout that, there will be milestones in terms of that support piece. So looking at implementing a variety of solutions across the regions to support and enrich the local care and protection panel across that 2 years. We're hoping that we'll have a midpoint evaluation at around 6 months in, and then a final evaluation around the 2-year mark.
Great, thanks, Kerry. So we have another question for Daniel and Dara, and it's from Alicia Buchanan at Naja, who says, hello to Dara from Naja. Do you have any insight into whether any movement in the NT to boost implement similar advocacy services such as your voice?
Again, the short answer to that is no, I don't have any insight. I will say that part of our dream of sharing this paper at ILAG, and we've also had a follow-up meeting with the National Children's Commissioner here in Australia, is to try and spread the word about the value of the service. When we met with the National Children's Commissioner, she was quite enthused with what we told her about the service. This, stop me if I'm out of line, Anne-Marie, but I think what I would say is we're trying to do what we can to raise awareness about the service and advocate for its relevance in this jurisdiction and elsewhere. But I would say that we're happy to share, you know, the background information. There's a lot of sort of background workings, like our program logic and funding applications and things like that. I would encourage you at NAJA, if you have ways into kind of the broader closing the gap work that's being done. I know that they're doing, from having working over there, there are opportunities to apply for funding through closing the gap and set up initiatives. So in the short term, I know you're crazy busy, but it might be a matter of perhaps meeting with us, hearing what we're doing and seeing if you could try and get funding to do something similar at NAJA. And in the meantime, we're trying to build an evidence base, and our hope and intention would be to share the evaluation outcomes and anything that could be of use to people in other jurisdictions, to try and support you to make a case for something similar in other jurisdictions.
Just before we leave that, one of the things that we're doing that we're quite proud of is we've built quite a strategic partnership with the Department of Communities and Justice about how we can assist them to achieve their goals through providing this service to children and young people in out-of-home care. Our philosophy is that you have a legal issue by being a child in out-of-home care. And we're sharing that philosophy with DCJ. They're receptive to hearing that message, and I think that's a key to how you need to think about working to develop that service in other jurisdictions.
No, I agree, yes.
Okay, so thank you very much, Dara and Daniel. Someone has asked whether we can share the PowerPoints with participants. I mean, that's clearly a matter for you as presenters, but
Dare say that's for Kira and Kerry, because people probably don't want a slide of us, our photos, but yeah, I'm happy to. We're happy to.
Yeah, definitely happy to.
Okay, that's great. All right, well, we've come to the end of our time and we don't have any more questions. So thank you everyone who did post questions, and thank you for participating in this panel session. I hope that you found today's webinar interesting and invigorating. Sorry, I certainly have. Many thanks too to all presenters today. You've given us lots of food for thought. Thanks also to Caitlin and to National Legal Aid for putting the webinar together today. A lot goes on behind the scenes to put these sessions together, and we appreciate your efforts. So all that's left for me to do now is to say thank you, and we look forward to seeing you at the next webinar. Goodbye, and enjoy the rest of your day. Thank you very much.